All righty, we're live. We'll just wait until we knock over to midday, which is now. Hi, Stace. How are you?
Hi, I'm well. How are you, Alice?
I'm doing well, thank you. Thank you everyone for joining us today for another exciting Insolvency Bites. I'll say snapshot, but it's actually longer than our little Insolvency Bites snippets. We're going to go through the case of McMillan and Warner today. And I think, Stace, we've got a few of these little case snapshots coming up where we're just going to run through probably a little bit dryly some of the, the facts of the case, and then we'll have a chat about what we think in terms of the decisions, how we think it might affect the way that we're doing things or what we've seen in the past, and go from there.
Yep.
So welcome to everyone in LinkedIn Live land. Firstly, we will record this and send a copy out to anybody who may have missed it. We'll also try and take comments where we can. If we can answer them, we will try to. If we can't, we'll take them under advisement, but please feel free to pop the comments up if we can see them. Before we get into today, I would like to acknowledge the traditional owners of the land on which I live and work, and pay my respects to elders past and present, and extend that respect and acknowledgement to any Aboriginal and Torres Strait Islander people on this call today. McMillan and Warner. This was a case that went to appeal early and was decided earlier this year, I think. Is that right, Stace?
Yeah, late February the decision came out.
Yeah, okay. And it's a case about Section 120 and 121, probably more particularly 121 of the Bankruptcy Act 1966. So we'll go through 121 in a minute, but you probably will know that the 120 and 121 of the Bankruptcy Act really are those sections that bankruptcy trustees use to claw back property that has been transferred out of the name of the bankrupt, but otherwise would have become an asset of the bankruptcy that can be realised for the benefit of creditors. They're pretty common. I would suggest, Stacy, that the vast majority of actions under the Bankruptcy Act probably have a 120 or 121 element. Would you agree?
I definitely agree, and if in doubt, throw it in there.
Indeed. There was some commentary that came out when this case or the appeal was decided that really had a chat about, does this affect a trustee in bankruptcy's ability to rely on Section 121 as much as we have been doing in the past? There was some concerns around what is the main purpose of a transfer. What does it mean to have the intent to defraud? And whether or not that's probably now a little bit more tight than it had been in the past. Spoiler alert, and I'll give a few spoiler alerts as we go. I don't think it does, just at the top end. I think that there was a number of red flags in this case that a trustee probably would have seen and potentially either was aware of and made the call anyway, or I don't know whether this particular trustee did examinations or that sort of thing. And this is some of the reasons we do those, to come, to get flushed out, I guess, some of the purposes and intentions behind transfers. But it's not always available, and it's not always the case that that's done. But I do think that there are a number of specific elements to this case so that it's probably not a carte blanche clipping of wings of insolvency practitioners to use Section 121 looking at that main purpose. Stace, do you have any general comments on that?
Yeah, I do. It's interesting because obviously you look at these things from the perspective of the trustee in bankruptcy, and I'm looking at it as a lawyer and as a litigation lawyer as well, and an insolvency lawyer. So my takeaway from this decision, both the primary decision and the appeal decision, is how could this case have been managed and conducted differently by the lawyers acting for the trustee? Are there things that they should have done that they didn't? Lines of inquiry and further evidence along the way that might have given this a different outcome? Possibly not. But there's enough in there to look at it and go, well, actually, this is a good decision for lawyers to be mindful of when advising trustees in bankruptcy, and also when actually prosecuting the action.
Yeah, no, I think that's a really good point. So what we might do today is we'll go through the facts. We'll go through, you'll hear a bit about me talking and it will sound quite dry at the front, but hold on there. I'm sure there are exciting bits to come. I'll actually go through section 121 as well, just to have a bit of a refresher on that. And then Stacy and I will go through the decision. And Stacey, you'll lead that discussion in terms of, what actually the appeal judges came up with at the end of the day, the points that they thought were relevant out of the grounds of appeal, and those that potentially weren't as relevant as Mrs. McMillan may otherwise have thought. So we'll go from that. Stace, please interject as I go. I think that's one of the best things about these chats, is where we can actually bring up some of the more conversational elements of what we're finding. And if anybody else has any comments they'd like to make, feel free to pop them in as well. So, as I said, this is a case about section 120, 121 of the Bankruptcy Act, and mostly 121. And that's because of the age, the difference between, and we'll talk to that, the time when the transfer actually took place and the actual bankruptcy that happened subsequent. So in particular, we need to look at whether the transfer by the bankrupt of a property in Strathfield in New South Wales was void as against the trustee in bankruptcy. So the primary judge found that the transfer was void, subject to 121, because the main purpose of the bankrupt in transferring the Strathfield property into the sole name of Mrs. McMillan was either to prevent the property becoming divisible amongst his creditors, or to hinder or delay the process of making that property available for division amongst his creditors. And that wording comes straight out of section 121. So Mrs. McMillan then appealed the decision, and she noted that the primary judge, she asserted that the primary judge wrongly departed from the case that had been pleaded against her, that he'd erred in rejecting Mr. McMillan as a witness of truth and rejecting his evidence as to the purpose in making the property transfer, that he erred in finding that the main purpose of Mr. McMillan in transferring his interest in the Strathfield property to her was, in substance, to prevent, hinder or delay the property from becoming divisible amongst his creditors, that he'd erred in drawing a Jones and Dunkel inferences by reason of the failure of Mrs. McMillan and the McMillans' accountants to give evidence, and by reason of the above, he'd erred in declaring the property transfer void as against the trustee pursuant to section 121 of the Act, and in declaring that Mr. McMillan's 1/2 share in the property vested in the trustee pursuant to section 58(1) of the Act. Right, so spoiler alert, the appeal judges concluded that the primary judge did not wrongly depart from the case that was pleaded against Mrs. McMillan, that he did not err in rejecting Mr. McMillan's explanation for the property or in drawing the Jones and Dunkel inferences, but he did err in finding that the main purpose of Mr. McMillan making the property transfer was, in substance, to prevent, hinder or delay the Strathfield property from becoming divisible among his creditors. So now we can tease out all of that. But first, and one thing that I'm actually curious about, not being the commercial litigation lawyer, Stacy, can you tell us what Jones and Dunkel principles are?
Oh, yes, I can definitely do that. So this is a principle and certainly a case that most lawyers will be very litigation lawyers, any lawyers entering the courtroom will be very familiar with, and we all learnt back in our uni days about this case. But just to express it really simply, the Jones and Dunkel principle, or the inference, is this: that the court will draw a negative inference against a party if there's a failure by that party to call a witness that should have been and was available to give evidence. Okay. So if you're conducting a trial and you're rolling out all your witnesses and there's a witness that isn't called, then it's open to the court or the judge to infer from that witness actually would not have been useful for your case. And that was the reason that you didn't call that witness to come forward and to give evidence. So it goes a little bit one step further as well. And this was clarified recently in another interesting decision around resulting trusts and a bankruptcy trustee, which we'll probably talk about, Alice, I think, in a future case review. Elderbell, do you remember that one?
Oh, yes, yeah.
Yeah, so that's this year as well. But it has to go one step further. It can't just be, that witness wasn't called, so they must have been going to give it negative evidence or evidence that would have hurt that party's case. There's a little bit of an assessment that needs to be made by the presiding judge as well, that person would have been necessary to give more of a true complexion on the facts relied upon by the parties. So there must have been a need for that witness, not just, or there would have been some utility in calling that witness. And in the absence of doing so, then it's open to the judge to draw that negative inference that, well, you're not calling him or her, then they must have been, a smoking gun for the other party. So that's what that Jones and Dunkel inference is. And we can have a chat about it in the context of the accountant's potential evidence.
Yes,
and
absolutely.
also the wife's potential evidence. Interesting that they didn't call. This is one of those interesting things about this case where it's like, well, if I was the lawyer, would I have called the wife in particular? Maybe not so much the accountant, but we'll get back to that.
No, that's very interesting. Thanks for that. I think it's one of those concepts that you sort of know about, but you don't know why or how.
Yeah.
So that's excellent. Thank you. Very helpful. All right. So let's look at Section 121 of the Bankruptcy Act. I also, it's very unprofessional, and a side note, I also think when you go through these, if you ever had a drinking game where you use the words transferred or transferee or property, then it would be a very sad, sorry event at the end of it when you go through some of these sections of the Bankruptcy Act. But here we go. Transfers to defeat creditors. So Section 121 sub 1, a transfer of property by a person who later becomes a bankrupt, the transferor, to another person, the transferee, is void against the trustee in the transferor's bankruptcy if A, the property would probably have become part of the transferor's estate or would probably have been available to creditors if the property had not been transferred, and the transferor's main purpose, and that's really what we're looking at today, the main purpose in making the transfer was 1, to prevent the transferred property from becoming divisible amongst the transferor's creditors. 2, to hinder or delay the process of making property available for division among the creditors. And we need to then look at how do we make that main purpose. So subsection 2 looks at the transferor's main purpose is taken to be the purpose described in paragraph 1B if it can be reasonably inferred from all the circumstances at the time of the transfer that the transferor was or about to become insolvent. So that's the easiest one that we look at. Is at that time that an asset is transferred from the transferor to the transferee, was the transferor insolvent or about to become insolvent? If the answer is yes, then you don't need to go any further. That's right, isn't it, Stace? That's the thing. The main purpose is deemed to have been to defeat the creditors, and you don't need to sort of read on. However, if you can't show at that stage that the transferor was or about to become insolvent, there are other ways of showing the main purpose in making the transfer. So subsection 3 notes that subsection 2 doesn't limit the ways of establishing the transferor's main purpose in making the transfer. It notes that the transfer is not void, however, subsection 4, notes that the transfer is not void if the transferee acted in good faith. So if a transfer of property is not void against the trustee, if the consideration that is paid was at least as valuable as the market value of the property, and the transferee did not know and could not reasonably have inferred that the transferor's main purpose in making the transfer was the purpose described in paragraph 1B, and the transferee could not reasonably have inferred that at the time of the transferor was or about to become insolvent. So that's a good faith element there. So we need to obviously keep that in mind. A lot of these cases, that market value doesn't come into it. That's the problem. I know in this particular...
Because don't you as a trustee in bankruptcy say, well, I don't need to void this transaction because we got full market value for it.
That's right, exactly. So it's just not something that we tend to look at.
Yeah. So it's pretty much a complete defense, and it just won't get off the ground in circumstances where, yes, and it's funny if we take a little bit of a segue and unpack the types of cases that we deal with when we're dealing with Section 121 sub 1, Section 121 sub 2, and Section 121 sub 3. So sub 3, the good faith is going to be easy to establish if you paid, $900,000 for a $900,000 property. And as I said, those cases aren't likely to get off the ground because the trustee will recognise that, it was a good faith transaction. But with that dare I say, not so subtle difference between 121 sub 1 and sub 2. That's really what this case puts a nice highlight on as well, because it's the 121 sub 2 cases which, as you said, Alice, are a little bit simpler for the trustees to establish and for the lawyers to argue, because it's hard to defend the good faith of a less than market value transaction that was entered into after receiving that creditor's petition or after receiving, that DPN from the ATO. Whereas 121 really does create a much higher burden and onus on the trustee to prove that intention to defeat, that main purpose. And that's why, that's where there's a lot of value in this case as a decision for us to be mindful of moving forward. But yes, please continue.
No, and I think that onus is a really important point, and I'll talk to that in a second, because the onus is on the trustee to prove this, and it's very difficult for a trustee, being a separate individual, to prove the intent of the bankrupt and why they did what they did. So it is actually quite a high bar, and we will talk to that in a second.
Especially if the transfer has occurred, like in this case, 18 years earlier.
So many, exactly.
Yes.
Going back quite some time. It's important that we also look at the rebuttable presumption of insolvency. So it's not enough just to be able to prove that someone was insolvent or was about to become insolvent. If they lost all the records that showed that they were solvent, then a trustee can rely on a rebuttable presumption of insolvency. So basically, if someone can't establish, because they haven't kept books and records, or the books and records never existed in the first place, that they were solvent at that time, then it is possible for a trustee to rely on the rebuttable presumption. They are presumed to have been insolvent if they can't prove otherwise. So that's something at least that provides a little bit of assistance in terms of that onus of proof. I always find subsection 5 quite... an interesting one. The fact that the trustee must pay an amount equal to the value of any consideration that the transferee gave for a transfer that is void against the trustee. I think 9 times out of 10, it just gets offset, doesn't it, Stacy?
Yeah, probably. But I mean, in the context of that $900,000 property, it may be that they paid $500,000 for it. And the trustee says, well, no, the creditors have been denied the opportunity of a full 900. So we'll take the property, void that, we'll pay you back 500 from the ultimate sale proceeds.
Yeah, exactly.
Yeah.
Great. And then it's important to note what doesn't have any value as consideration in terms of these transactions. So the fact that the transferee is related to the transferor, not that we can help that sometimes, but that is no consideration in terms of a 121 claim. If the transferee is the spouse or de facto partner of the transferor, the transferee making a deed in favour of the transferor is not considered consideration. A transferee is promised to marry or to become the de facto partner of the transferor is not consideration for the purposes of this section. The transferee's love or affection for the transferor. So that's the usual. We often see, was it transferred on the transfer document, natural love and affection. So this explicitly shows us that natural love and affection, as unromantic as it seems, is not considered valid consideration for the purposes of Section 121 of the Bankruptcy Act. If the transferee is the spouse or a former spouse of the transferor, the transferee granting the transferor a right to live at the transferred property, unless the grant relates to a transfer of settlement of property or an agreement under the Family Law Act. And if the transferee is a former de facto partner of the transferor, the transferee granting the transferor a right to live at the transferred property, again, unless it's under an agreement under the Family Law Act. So just... I guess an exemption, property can't be clawed back pursuant to Section 121 if it was property that was under a debt agreement. So that's just an unusual carve-out. Although I'm curious, and I've actually come across this as recent as yesterday, if that debt agreement is not fully effectuated, does it then fall back into the case? So we had a matter where there was property and it was under a debt agreement, but the debt agreement was then failed to complete.
Right. Yeah.
So we're now looking at whether or not that is actually valid or not. So we'll see.
Yeah, that's interesting.
Yeah. And it's also important to note that, if the property is on-sold to a third party at arm's length and for market value, then, that third party is not, roped back into this proceeding to claw back the property. They can, I think, as I understand it, enjoy the property as they can, and the claim is against the initial person to whom the property was transferred. All right. Important also to note that transfer of property includes a payment of money, and also that a person who does something that results in another person becoming the owner of property that did not previously exist is taken to have transferred the property to the other person. The market value of the property transferred needs to be the market value at the time of the transfer. Sometimes that's something that can get confused, whether or not it's market value at the time that the trustee is making the application. No, it's when the actual property was transferred. That's when we need to look at the market value. All right, so that's 121 for us. Everyone can go and read that separately if they need to. Hopefully everyone's still with us and hasn't fallen asleep. But I think what we're looking at is main purpose in the McMillan case. And there's a few interesting matters that the judges in the appeal raised, and they were the points that came out of a case called Canane and J. Canane Proprietary Limited in liquidation, and also some points out of Prentice and Cummins. And I'll just go through those points now, following which we'll go through the actual facts of the case. So I think it's important that we have all this background before we actually unpack what happened in the actual McMillan case. So from Canane and J. Canane Proprietary Limited in liquidation, in that case, it was noted that a party seeking to avoid a disposition of property has the onus of proving the actual intent by the disponer at the time of the disposition to defraud creditors. So that's what we were talking about earlier. It's the trustee in bankruptcy's onus to be able to prove the intention of the bankrupt at the time that they transferred the property. The intent prescribed by Section 121(1) is an intent to defraud any present or future creditors. Any present or future creditors. But as the intent must accompany the disposition, it must relate to the effect of disposing of the property that is then existing. So the property needs to have existed at the time it was disposed of to put it out of the hands of any present or future creditors. Section 121 is not enlivened merely by showing that a disposition has reduced the assets available to the creditors when the disponer is adjudicated as being bankrupt. It is the disponer's intent to deprive creditors of the assets against which or against the proceeds of which they would otherwise have been entitled to prove their debts that enlivens the operation. So it's not enough just to say, well, I had this asset and now I don't have it anymore. It needs to have been an asset that would have actually been able to have come into the bankruptcy and be able to be realised for the benefit of the bankrupt estate. So an easy one for me thinking that is if there was a loss in super, or if there was a property that was purchased, using loss or, trauma funds that would not otherwise be actually available to a trustee in bankruptcy, and someone's disposed of a property that's been quarantined for those purposes. Well, that's not a 121 because those assets would never have come into the bankrupt estate in any event. And finally, from that case, the phrase intent to defraud creditors of the company suggests that present or future creditors of the company will, if the intent is effectuated, be cheated of their rights. An intent to defraud creditors has been described for the purposes of bankruptcy legislation as an intent by deceit to deprive creditors of something to which they are entitled. So I think that's really I think it's straightforward, but it's important for us to sort of go back to that. Sometimes we get a little bit carried away in what it all means. And it's just really, was it there to start with? Would it have been available to the creditors? And is it there now? In my mind, that seems to be, a pretty straightforward way of looking at it. The issue is, what was the intent behind the disposal? And that's what we're sort of looking at today. Just following on from that, Prentice and Cummins noted that the following principles applied. So firstly, if a trustee doesn't rely on the presumption of insolvency, it will be necessary for the trustee to establish that the transferor's subjective purpose fell within the purposes described in 121 1B. So that's, I think, quite straightforward. Secondly, the expression main purpose is not defined in the Act, but is explained. A transfer of property will be within section 121 1B if the transferor's principal or leading purpose was to prevent the transferred property from becoming divisible amongst his or her creditors, or to hinder or delay the process of making property available for division amongst the creditors. So the transfer can then be caught by section 121, even though the transferor had other purposes in mind. So I think what they're saying there is the main purpose is the leading purpose. So it's not as though it's the only purpose. And I think that's really relevant here. So there might have been a number of purposes of which why a transfer had completed, but realistically, what is the primary, what is the main and leading purpose? Is that how you think of that as well?
Like the dominant purpose argument.
Absolutely. All right. So thirdly, and we've noted this a couple of times, the trustee as the party seeking to set aside the transfer bears the onus of establishing that the terms of section 121(1) have been satisfied. And a court can infer that in all the circumstances, independently of the solvency of the transferor, a transferor's main purpose was that described in section 121 1B. So it's up to the court to decide. Is that right?
Yes.
So the transferor's main purpose may fall within section 121 1B, even at the time of the transfer, the transferor has no creditors or is able to satisfy all of his creditors. I think that's really important. And we come across that quite often where, if we're making a claim subject to 120 or 121 in particular, 121, the first thing that comes back to us is, well, there was no creditors at the time. It's like, yes, but what was about to happen? Let's step back and actually have a look at the whole situation in terms of that transaction. And I think that's an important one here as well. It doesn't matter that there weren't any creditors at that point. It matters about what was going to happen next. And I think that's really relevant.
It certainly captures, and they talk about this in the decision, present and future creditors. And I always use this case as an example quite often, the High Court's ruling in Cummins and Cummins, which is a 2006 decision. And for those who don't know it, I haven't looked at it recently, but in really simple terms, the bankrupt was a barrister, and he made a disposition of property to his spouse. I think it's like 25 years prior to his bankruptcy. It was a long time. And at the time of the disposition or the transfer, he wasn't on the verge of insolvency and certainly not insolvent. And the creditor was the ATO. And he didn't have extensive ATO liabilities at the time, but he had a lot of unlodged returns. So the reason he didn't have those liabilities was because the ATO didn't know about all the income that he was reporting. So the ATO was certainly a contingent or a future creditor. And it's an interesting case to read. Maybe one we'll put on our case notes updates for the future too, Alice. But 25 years is a long time. And McMillan and Warner, the first thing I saw was like 18 years.
18. It's a long time, absolutely. And I think the difference between Cummins and McMillan, and I mean, there's a lot of differences. They're on different, different streams. But as you said, there was the tax issues, and they were at that time they were still a relevant issue. Whereas in this particular case, what seems to have happened 18 years later seems to be totally separate from the events and the creditors that were involved, at the time of the transfer. So I think the specificities of cases are really relevant, and sometimes we can, especially as some insolvency practitioners and not necessarily lawyers, we sort of chunk them into these little categories. Oh, that means we can't do that, or that means we can do that. And it's really important, I think, to tease out, sort of the intricacies of each of the cases, because they're not always as straightforward, I think, as we like to think that they are.
Absolutely. And that point you just made about the connection, and they talk about that in this decision. One of the reasons, you've already given them spoiler alerts anyway, is the lack of any temporal connection, they say, between the transfer and then those events that ultimately resulted in Mr. McMillan's bankruptcy. Whereas, as you're saying, Cummins, there was that temporal connection, so to speak, because of the ATO's position.
Absolutely. All right, so the final point from Prentice and Cummins here is if a person makes a voluntary settlement immediately before entering into a financially hazardous venture. Now, that's a phrase that will keep coming up as well in this matter. Financially hazardous venture, this could establish an intention to defraud his or her creditors, notwithstanding that there were no outstanding creditors at the time of the transfer. And that really talks exactly to what we were talking about then. And I think there is a really old case that I keep going back to. I think it's sort of, ye olde England, where the greengrocer decides to start a butcher's business. And it's all about the fact that he was never a butcher, didn't have anything to do with being a butcher, but why should his creditors...
riskier than vegetables?
Well, apparently. And because he didn't know what he was doing, they're saying, why should his existing creditors, have been subject to his hazardous venture where he could have potentially been protected? I don't know why some random printing is coming out of my printer that I didn't send there. So apologies if there's any external noise. All right. So that's the basis. Let's go to the facts. We'll go through the facts of McMillan. I'm going to just point out as we go where I saw the red flags in the trustee's case. Look, hindsight is 2020. It's always a marvelous thing. I'm not suggesting for a second that anything was overlooked. I've been subject to things before where you get one lot of information from one party and then they provide another lot of information to somebody else, and that's expected that you had that information and you didn't. So I'm not asserting any I'm making any comment at all at how the matter was dealing. I'm just looking at, from what we know now, I think where the red flags are and why I think that this case doesn't necessarily hinder what the position is for a trustee in or Section 121 main purpose case going forward. I hope that makes sense. All right. Mr. McMillan commenced a panel beating and spray painting business in 1990 called McMillan Prestige Car Repairs Proprietary Limited. Some of the cars he repaired were Prestige motor vehicles. In May 1995, Mr. and Mrs. McMillan purchased the Strathfield property as joint tenants. Part of the purchase funding for this came from a CBA loan and part came from Mrs. McMillan's mother. So for me, that's the first, that's red flag. The balance of the purchase price came from the sale of a previous property, which they called the George's Hall property, and that was owned by Mr. and Mrs. McMillan. So it's a point to note that the George's Hall property was purchased in March 1991, and it was purchased from proceeds of the sale of two other properties that were owned solely by Mrs. McMillan. So again, that to me is a red flag.
Massive.
So in 2000 and 2001, a proposal emerged from Rolls-Royce that would see Mr. McMillan operate a car dealership in addition to his Prestige car repair business. So there were some conditions put in place by Rolls-Royce, and these would be funded by a $50,000 interest-free loan by Rolls-Royce or from Rolls-Royce for the purposes of establishing the new operation. In April 2001, the CBA provided a loan facility to McMillan Prestige Car Repairs to purchase two vehicles as stock in the dealership, and this loan was secured by a guarantee, joint and several unlimited as to amount from both Mr. and Mrs. McMillan, and a second registered mortgage over the Strathfield property. So again, that to me is a red flag. In June 2001 or 2001, Mr. McMillan received a letter from Rolls-Royce in which they talk about the lack of visibility over the business potential cash flow concerns, and encouraging Mr. McMillan to look to full floor plan finance options. Mr. McMillan took that encouragement and took steps to secure a temporary facility. So at that time, so that's pretty much what I think where we look at sort of the baseline. And at that time, the McMillan corporate structure consisted of McMillan Prestige Car Repairs, and that was owned 40% by Classic Auto Search Proprietary Limited and 60% by Mr. McMillan. Mr. McMillan and Mrs. McMillan each held 50% of the shares in Classic Auto Search. So again, to me, that's a bit of a red flag. Classic Auto Search was the corporate trustee of the McMillan Family Trust, the McMillan Investment Trust, and the McMillan Superannuation Fund. Mr. and Mrs. McMillan were the only members of the super fund, and the super fund was a sole unit holder in the McMillan Investment Trust. I just want to point out at that time, so when I keep talking about Mrs. McMillan's involvement in the company being sort of a red flag, I think it's important to note that she's almost as at risk here as he is. We often see in these Section 121 cases where, there's one party that's heavily involved in a business and the risk associated with that business, and there's another party who just isn't. For all intents and purposes, they may have a separate job, they may have a separate income earning capacity, they may do other things, but their income is not necessarily reliant on the business of the first person. And also they're not as involved from a risk perspective as a director, for example, or providing, unlimited guarantees, etc., that would, even if they were taken out of the situation, those guarantees, are still there, unless they're sort of treated otherwise by the creditor. So I think that's important. Stace, do you agree with that?
Yeah, I do agree. Definitely. Yeah.
All right. So in September 2001, and this is where things start escalating quickly, St George provided McMillan Prestige Car Repairs with an indicative finance facilities offer, which included a bailment facility of $2 million and an import letter of credit facility for $1.5 million. And the supporting security for that loan would include a first-ranking fixed and floating charge over all the assets and undertaking of McMillan Prestige Car Repairs. Good to talk about fixed and floating charges. I'm not been allowed to talk about fixed and floating charges. A first-ranking mortgage over the Strathfield property, so again, another red flag. Guarantees and indemnities from Classic Auto Search, Mr. McMillan and Mrs. McMillan. And then also in September 2001, the CBA approved an increase of $975,000 to an existing facility, which was already $300,000 for Classic Auto Search to purchase properties from which Prestige Repairs traded from. And then again, security for that included joint and several guarantees from both Mr. and Mrs. McMillan, a second mortgage over the Strathfield property, guarantees from McMillan Prestige Cars, and then mortgages over the properties at 19, 21 and 23 Regatta Road. So that was the property that they were trading from and that they were purchasing. And an equitable mortgage from Classic Auto Search and the McMillan Investment Trust. So again, all of these entities with which Mrs. McMillan is also intricately involved. In November 2001, Mrs. McMillan ceased to be a director of McMillan Prestige Car Repairs. St George Finance came through and paid out CBA's mortgage over the Strathfield, and Mr. McMillan executed a mortgage. I thought this was an interesting point. I don't know that it flows through that much, but he signed a mortgage over the Strathfield property in favour of St George, and he signed for himself and also under power of attorney for Mrs. McMillan. So that was just an interesting point that came out. April 2002, Volkswagen Financial Services entered into the floor plan facility executed by Mr. McMillan as sole director now of Prestige Car Repairs, and the maximum prospective liability under that facility was $5 million. Now, May 2002, so that's a month after the Volkswagen facility comes through, Mr. and Mrs. McMillan seek estate planning advice. At that time, the Strathfield property was valued at $800,000. I have a question that says, if the property was valued at $800,000 and it was subject to all of these other securities, realistically, what was the equity at the time? That I don't think is actually raised as part of this case, but that's something I think would be relatively relevant to looking at what actual equity was transferred to Mrs. McMillan from Mr. McMillan.
And would you, as a trustee, Alice, undertake that line of inquiry before embarking on this litigation?
Yes. That doesn't mean to say that I would have done anything differently, because as we've seen, there's a number of securities.
Yeah.
In terms of, it depends on what the valuations and how well the other businesses were travelling. They may have been able to fully support those securities in terms that the mortgages over the property may not have actually been required by the commercial lenders. But see, for me, there's a lot up in the air on that in terms of what equity was there. I would definitely have done that, but it's not an easy question to answer, and it is also, it's also something that different people with different risk profiles and different experiences may look at differently. So then, between May, June, and July of 2002, a transfer was signed, transferring the Strathfield property from both names and into Mrs. McMillan's name only, for the stated consideration of $1. Now, that's intriguing to me because it's not natural love and affection. They actually put $1 on it. Can you think of any reason, Stace, that they might have done that? I'm not sure that there is one. But...
No, look, I don't know. I mean, you've pointed out in going through section 121 that natural love and affection isn't valuable consideration, whether $1 was used expressly to avoid it being obvious that that natural love and affection isn't valuable consideration. Look, I don't know. It's interesting. I don't know whether he did it on advice or not. But certainly natural love and affection wouldn't have got him anywhere anyway because of the provisions in the Act. But $1. His evidence at the trial was that it was because he loved his wife.
Exactly. I wonder, though, if, given what we just spoke about in terms of the equity in the property, if a memo had been drawn and produced that said, we've sought a valuation of the property, it's $800,000. The security that is against the property is in the vicinity of $5 million plus $10 million.
Yeah.
Accordingly, there's no equity in the property, and therefore we will transfer for the nominal amount of $1. Whether that would have solved all the problems. I would have suggested it wouldn't. You'd probably still have a go. But you wonder how far down the road that would have gone to say, well, there wasn't anything there anyway. It was transferred at market value. Nothing to see here.
Yeah.
Easy to look at those things now. But
that
was one of those things that I sort of
create that case for them in hindsight. And if it was true, though, you would expect that advice I mean, there's no evidence. Nobody's testified.
But if you put Mr. Vince on the stand.
Exactly.
Which you didn't.
Presumably he wasn't going to testify that, though.
Well, yeah, that's right. You'd think that he probably, if he was going to give that advice, he would have.
Yeah, because that would have been very helpful.
It would have been, absolutely. But anyway, again, we're just talking hypothetically, and that's probably not helpful. In June 2002, the trustee of the McMillan Family Trust was changed. So that was interesting. But the trust itself retained the 40% of prestige repairs. 19th of July, Mrs. McMillan executed a mortgage over the Strathfield property in favour of St George, recording Mrs. McMillan only as the sole mortgagor. All right. On 12th of December 2002, CBA provided an $850,000 facility to the new trustee of the family trust. And again, that was secured by mortgages over the Strathfield property and personal guarantees from Mr. and Mrs. McMillan and Prestige Car Repairs. And to me, that, again, is a red flag because that's happened after the transfer. So that's sort of showing that there's this continuation of her involvement within the corporate structure and putting assets of hers or her personal position at risk at a time after they've actually gone to all the effort to transfer things.
Do we know, I should know this, but you're across the facts well better than I am on this one, if those were also signed under the power of attorney?
There's no mention of that from what I've seen. Yeah, and it's interesting that they've noted the other one.
You've noted the other one, and I know here in Queensland there's a provision in the Powers of Attorney Act where if the attorney enters into a document using the power of attorney granted by the can't remember the expressions, the appointor of the attorney, then a rebuttable presumption of undue influence will arise in circumstances where the attorney stands to benefit from that transaction. So you have to be very careful when you're acting as an attorney that you're not signing off on a document or exercising those rights and signing on behalf of your appointor, that you stand to, get some financial or other benefit or gain from that transaction. Here, for that earlier mortgage, certainly he was. New South Wales, I'm probably about 90% confident there's a similar provision, but I'm not 100%.
No, that's really interesting, isn't it? No, it is. And I think that it's important for us all to realise sometimes how much, and we've discussed this before, but how much, I often just think that the Corpse Act or the Bankruptcy Act is the Bible, and you often say to me, no, you need to start thinking about, whether a specific Land Titles Act applies in certain situations or whether there's an estate, or trusts element that applies.
Certainly.
And I think
So
that's
there's
important.
always a whole host of other legislation that we need to have regard to. Property Law Act often with trustees in bankruptcy. And the Powers of Attorney Act, irrespective of the jurisdiction, there'll be a relevant legislation in each. Should be had regard to if there's any transactions which have been entered into as an attorney.
No, really relevant. Thanks, Stacy. All right, we're almost at the end of the facts. Then we can actually talk. Hopefully we get to that before the
decision. Until next time.
No, that's it. So 2004 now, the car dealership expands again to include a Volkswagen dealership. And then fast forward all of this time, on the 6th of November 2018, a sequestration order is made against the estate of Mr. McMillan. All right, so Mr. McMillan tries to explain the main purpose behind the transfer of his share in the property to Mrs. McMillan. And he's basically said that it happened shortly after Mrs. McMillan's father passed away in 2002. Now, I wonder, and I'm not sure, it might have been late 2001, but that power of attorney element, I've got a feeling, I don't know, again, I'm not pleading anyone's case for them, but that seems to have sort of been contemporaneous around the time that maybe the father-in-law passed or may have been unwell. I'm not saying I'm putting words in mouths, but given that's the only time that seems to have popped up, that's what I'm sort of thinking. So Mr. McMillan's father-in-law, so Mrs. McMillan's father, passed away, and she basically said to him, I want the house in my name. It should have been like that all along. And I guess if you fast forward, or so rewind back, she's the one who purchased the Georges Hall property that went, the purchase price went in. The mother, gave some money for the deposit. And whilst, I think we can suggest that Mr. McMillan would have had some input and, sort of maintenance into the property, we can see that, her making that statement may be a valid point. However, the primary judge didn't see it that way, and he sort of said that without necessarily rejecting the evidence of Mr. McMillan, reasons for reservation spring from a series of challenges made to his credit and the reliability of his evidence by senior counsel on behalf of the trustee. Although other particulars separately expose further reason to question the reliability of Mr. McMillan's evidence, for present purposes, it is difficult to unquestionably accept his account that the Strathfield property was hers anyway, in circumstances where the finance provided by the CBA by way of mortgage to inter alia purchase the Strathfield property was a joint mortgage. So that's fair enough. I get that, between both Mr. and Mrs. McMillan. The deposit of $32,000 initially provided for by Mrs. McMillan's by her mother was actually repaid, apparently, by McMillan Prestige Car Company. So, okay, fair enough. The mortgage repayments were paid by McMillan Prestige Car Repairs. So that's, I think, relevant. But also, she was as involved in McMillan Prestige Car Repairs as he was. So you sort of wonder, just because that's where they came from, how should have they been distributed? I don't know the answer to that, but that's an interesting point. And so that Mr. McMillan's account of the circumstances in which the transfer of his interest in the Strathfield property to Mrs. McMillan could not be accepted. So that's basically where that went. So draw a line there. Matter goes on appeal. We've heard now the facts and we went earlier to the grounds of the appeal. Shall we go through, Stace, what we're thinking of in terms of the ultimate decision? Now, this pleading and credit appeal grounds, you were saying to me it's never a good appeal unless you put a pleading point in.
Well, I didn't say that in front of an audience. I said that to you. Only if there are good grounds. I mean, I would never advocate for filing an appeal or putting grounds that didn't have merit. But if you can attack the pleadings, you should.
Very good.
Oh, you're funny. Thanks for that.
No, anytime. Sorry. So my understanding is that, and Mrs. McMillan is saying that the primary judge didn't actually point to a specific part of Mr. McMillan's evidence or the trustee's case that said that this was the main purpose. Instead, there were a number of points, and he drew on a number of points together to come to the outcome that the main purpose of the transfer was to defeat creditors. That's your reading?
Yeah, that's right. And so one of her grounds was that the trustee had therefore wrongly departed from the case that had been expressly pleaded. And those pleadings are really important. I mean, Mrs. McMillan is entitled to be fully appraised of the case that she needs to meet at trial. But ultimately, that ground was not upheld anyway. And the full federal court didn't take issue with that.
Yeah. So they said there was no drama with joining those dots. They had no real issue with that.
Yeah.
And so then Mrs. McMillan challenges the adverse credit findings made by the primary judge against Mr. McMillan. What do we think about that? I don't think the appeal judges had much of an issue with that. Would that be right?
No, they didn't. And it's interesting. It's very difficult on appeal to consider credit findings and whether or not there's the witness is a witness of truth. The primary judge has the benefit of seeing that witness in the witness box. And it really is very difficult on an appeal for an appeal court, in this case, the full court of the federal court, to get a feel for how that witness actually performed in the witness box. So that ground was overturned as well, or not upheld. But it's an interesting one because the primary judge, when he was talking about the Jones and Dunkel inference, found that the failure, and stated in his reasons, that the failure to call the accountant and Mrs. McMillan really bolstered, and used that word bolstered, his view about the credit finding as well. And perhaps it just goes to show that sometimes little things can really tip you over the edge. So the combination of him not perhaps coming off as credible in the witness box as he could have, together with that, failure to call the accountant and failure to call Mrs. McMillan, really bolstered his view of and relate to that adverse finding. So it's something that lawyers need to be really conscious of. But again, here, neither of those grounds got up. So
no, that's right, isn't it? Absolutely. All right. So then we turn to the inferences as to the main purpose for the appeal grounds. And I think they sort of look at the whole situation. Sort of one of the things they looked at, I think the trustee was sort of asserting that Mrs. McMillan started stepping out of the picture, I think is the term they used, from 2001, before the property is transferred in 2002. And I think the appeal judges note that that isn't necessarily the case. And there's actually what they call subsequent inconsistent dealings that don't support the trustee's position that Mrs. McMillan was stepping back from that position. And I think there was a few things with that. So there was security given to secure the new trustee's CBA loan in 2002, and we raised that earlier. That included a mortgage against the property and guarantee given to by Mrs. McMillan. Yeah, and that's at a time after the property's been transferred. She then also gave a guarantee to CBA with respect to the loan made to Classic Auto Search as trustee to acquire the commercial properties that they were dealing with and purchasing. So the appeal judges, I think, were satisfied that the primary judge did err in not taking those events into account in drawing inferences as to Mr. McMillan's main purpose in making the property transfer, and noting that they present significant hurdles to drawing an inference that the main purpose of the property transfer was in substance to prevent, hinder or delay the Strathfield property from becoming divisible amongst Mrs. McMillan's creditors. And I think that's really the crux of it, isn't it? That's a big part of it.
Yeah, definitely. I mean, I made some notes of the key ones, certainly, because it's the finding of that main purpose, which is the issue. So I can't remember how many appeal grounds there were, but there were several, and it was only this one that Mrs. McMillan got up on, and it's the key one. It's the main one, the main purpose ground. And in overturning that finding, what the court placed weight on was, as you've mentioned, the guarantee that she provided for the St. George loan, which paid out the CBA loan, the mortgage granted to St. George, what we were talking about earlier, which is that lack of any temporal connection, they called it, between the transfer and the ultimate liabilities that led to his bankruptcy. They also found that the new business venture of the dealership was not a risky venture.
No.
And it represented more of just a diversification of Mr. McMillan's existing profitable business in a related activity, in a related industry, and interestingly, with full support of Rolls-Royce. So he had all that backing from those dealerships, or Rolls-Royce and Volkswagen. The other thing they looked at and found that the financial information suggested at the time of the transfer that the company had surplus working capital, and was in a solid position. There was significant cash at bank. They also spoke to the lack of evidence that the creditor that would have been most affected by the property transfer, well, if you go back to the time of the transfer, which was Volkswagen, it didn't request any security over that property, which is a key point as well. And then, of course, that 18-year period, which is that temporal connection argument. So, the combination of those things really challenged and ultimately defeated the primary judge's consideration of that, that intention being the main purpose. So having looked at that, and we have to remember here, the key things for us to remember is that the onus is on the trustee to prove that main purpose. And the court isn't going to infer that main purpose if there are other equally likely inferences that can be drawn from all the facts, all the circumstances. And that's why just going through those earlier ones is important to do. I love this case, Alice, because, and I know you and I have had a quick chat about it offline, we are both in what people would call a risky profession, a risky business. I think you and I are a little bit similar in that we're quite conservative. I'm conservative. There's no doubt about that. I don't consider myself at risk at all, because unless I am really blatantly negligent, probably more so fraudulent, in order to avoid any insurance policies that I have, and I am insured, I can't see myself in a situation where I'm going to be exposing all my family assets. But before this case, I know that clients, particularly professional clients, when I'm talking to them about asset structuring or estate planning, and we talk about the provisions of the Bankruptcy Act, and we say, well, yeah, but just be careful, because if your intention here is to defeat creditors, then that act's taken us way back 25 years and then some. It's not just the last 2 to 5 years that you need to worry about. So this case is a nice one. I know that we've been talking from the perspective of the trustee in bankruptcy, but also, if your main purpose is not to defeat creditors, then there's still some benefit to doing some solid estate planning and asset structuring where you can.
I think it's the case that gives a lot of perspective on a lot of different things, doesn't it? And I really like that about it. I think we've had that discussion as well. It just also makes someone from my perspective just sit and go, okay, I need to tick off a few things. And we always do that anyway, as you said, sort of in best practice and making sure that we've got all our ducks in a row. But it's nice to sometimes, especially to your team or sometimes your legal team, depending on who they are, say, this is why I want to be really confident that we've got a case here that's not going to be problematic in these areas, because they thought they had it. The first judge, they did. And but this is what happened.
The federal court got involved.
But here we are. So I think that's probably a really good time to wrap that up. That was a great chat. I always get a lot out of our chats. I know that I hope others do as well. It's good to be able to bring out the bare bones of different matters and look at the different, specific elements of the cases. And I mean, I've learned some stuff, thank you, in terms of the Jones and Dunkel bits and pieces. And I really appreciate that we can get to do this. I think we've got a few on our list. Now, if anybody has any cases that they'd like us to do a bit of a run through, make sure you reach out and let Stacy or I know. We're always happy to look at that. Next month, I think we're going to look at Bosanac. Is that right?
Yeah, we certainly can. I think Bosanac's a good one to discuss as well.
And that sort of deals a lot in the area of resulting and constructive trusts.
Yes.
Another interesting area.
So let's talk about the difference between those two things.
Let's do that. They're not like the 120, 121. They are separate. They are very nuanced.
Yes.
They're just always thrown in together.
Yeah, exactly. That's right. If in doubt, plead both.
Thank you so much, Stacey. Always great to catch
up.
Thank you, everybody that's there. And if there's anything that we can do to help you in your way, reach out and let us know. Until next time. Cheers.